Killer, 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 killer cross-examination. A podcast by your host, the nationally renowned criminal defense attorney, Neil Rockind.
This is Neil Rockind, your host of Killer Cross-Examination, the weekly podcast where we bring to you current events, issues related to cross-examination, the confrontation of witnesses, confrontation of individuals in your own personal life, the ability to discover and get to the truth, or at least to reveal that people aren't being truthful or honest, and a whole variety of criminal justice related topics. This week on our podcast, I want to talk to you about something that's really fundamental, and it's the presumption of innocence. So everybody who has heard of or has been around the criminal justice system has heard of the phrase, the presumption of innocence. We know what it means. It means that you're supposed to presume the person who's accused of a crime to be innocent. That means that as you sit and judge a particular case, or as you sit and evaluate a particular accused, you are to presume that that person did not commit the crime and that they are in fact innocent. And then what the law says is until, believe it or not, the law says until the state proves or the government provides evidence beyond a reasonable doubt. And juries are told that that presumption of innocence continues all the way through the trial and through the deliberations up until a jury reaches a conclusion or an opinion that the state or the government has provided proof beyond a reasonable doubt. And I want to talk about that for a second because, first of all, one, in society, we are getting further and further and further away from the presumption of innocence. And second, in our courtrooms, that presumption of innocence is being turned on its head. And third, the jury instruction that I just read to you, what juries are told, is in many cases being abandoned by jurors, maybe even in some cases at the suggestion or subtle encouragement of the state in voir dire, which is when we pick a jury, in opening statement as we begin to put on our case, and all throughout the trial. And I want to talk to you about that because the presumption of innocence is one of the cornerstones of not just our legal system, but it's a cornerstone of our society. So let's think about that for a second. The presumption of innocence, it's sort of fancy language. What does it mean? It means think the best of the person, right? That's what it really means. It's sort of a legal application of the golden rule, which is believe the best in another person. And until there's proof, until there's concrete, absolute, nearly undeniable evidence that that person committed a crime, believe that he or she didn't. It's an application of the golden rule in many respects. It really isn't that hard to imagine. It means that it's not a technicality, as we hear people in the news or pundits on several news channels say when some talking head like me raises the idea that a person accused of a crime is presumed innocent, and we wish to encourage people to presume them innocent, and instead we hear some talking heads say, "Oh, well, that's just a technicality." Or we hear a person actually who's acquitted of a crime, and that person we hear again the aftermath is they're still judged for having committed the crime, even though they were acquitted, even though they were presumed innocent and found to have not committed the crime beyond a reasonable doubt. They still have to live with the accusation in their own personal lives and in the legal system for months, years, and maybe even a lifetime to come. And it's sickening. It's sickening how far away we are getting from thinking the best of our fellow citizens when another person or the government makes an accusation against them. We aren't really presuming people innocent at all. Somebody gets charged with a crime or gets merely accused of a crime, Or even worse nowadays, there's some news release from a civil or a criminal case, or a civil or a case or an investigation, and somebody puts out a press release, or someone makes a news statement, or documents in a case are released, and the people whose names are mentioned in the press release are immediately on social media treated as though they are guilty. The lock her up, lock him up, throw away the key, line him up and kill him, stick him in a cell where we'll never hear from him again, lock him up and take away the key. We keep hearing this stuff over and over and over again, and it is in the absence of, in many cases, a conviction, and in a lot more cases now, in the absence of even a criminal charge. Our social media and our news information is so inundated and so partisan, and we're so quick, our attention span is so short, our tolerance for other people is so limited, it seems, that when someone is merely accused, if they're investigated, if they're under investigation, if their name happens to appear in a pleading or in court or mentioned in court, society just jumps all over them. It's like a shark feeding frenzy. And the few people like me that jump in and say, she's presumed innocent or he's presumed innocent, we get pushed away, we get shrugged off as though somehow we're relying on some technicality. So I ask you, how in the world are we supposed to expect citizens to get a fair trial, to be presumed innocent? In other words, to be presumed to have been their best and not committed this crime, presumed that there's not enough evidence, presumed not guilty, if our society is having a harder and harder time applying that principle to people every day. How can we anticipate, how can we expect and hope that people who in their own personal lives jump to the conclusion that a person accused is guilty, or jump to the conclusion that a person in their professional life is guilty merely based on an accusation or supposition, or worse, they read something in the paper about someone who was mentioned, who's under investigation, and they say, oh, lock him up, or toss him down a well, or I hope he gets to spend 50 years in a cell with, who knows who, and all of the parade of horribles are trotted out about the things that should be done to this person, all before they're even convicted or charged with the crime. How do we expect citizens, how can we honestly believe that citizens who feel that way can then come into court as potential jurors and say, yeah, I can set aside my feelings, I can judge this case, I can presume him to be innocent? You can't. We can't live our lives, on the one hand, presuming people to be guilty and thinking the worst, innocent until accused, if you will, but then expect those very people to be able to shrug and to put those feelings aside and to judge citizens who are actually accused of crime in court fairly, objectively, and presume them to be not guilty. I keep reading about it in the paper. I keep looking at it on Twitter. And the comments when someone is merely mentioned, arrested, or mentioned to have been under investigation are disgusting. They're overwhelmingly negative. And people just want to jump on seems like everybody just wants to sort of stone that person to death, if you will, figuratively, before they even have their day in court. But then the same people that are doing that, we expect to be able to come to court and set those feelings aside and be honest, reasonable, and reliable jurors. Those two things don't match. They don't gel. And in order for us to be able to have citizens who've honestly applied the presumption of innocence in court, we got to start thinking better about people when they're simply accused. That leads to my second thought, is that we have prosecutors who put out statements when police officers who do press releases when people are charged with a crime, and prosecutors issue press releases when people are charged with the crime. Have you read those things? Those press releases are, in essence, they go through an entire paragraph, 2 or 3. There's a mention of the charge, there's a mention of the accusation, there's a mention of how committed the prosecutor or government agency and the police department is to eradicating crime. And then in one line at the very bottom, after they've just pounded this guy into the ground with allegations and insinuations, at the very end of it, there's oh yeah, by the way, everybody accused of a crime is presumed innocent. You just spent 3, 4, 5 paragraphs and a bunch of time on the news in front of the cameras, throwing rotten vegetables, tomatoes, and eggs at this person, saying how proud you are of law enforcement, how happy you are that this crime was solved, how the office intends to seek and obtain justice, how the victims of crime were protected here, injured by the accused, but are being protected by law enforcement. Oh, but by the way, a person accused of a crime is presumed innocent. That's like said almost as an afterthought. It might as well be in a footnote. Maybe even a footnote in a foreign language in tiny, tiny, tiny print. It's becoming a problem. We're getting to the point, it seems, where people are presumed innocent until accused. And agencies are paying lip service to the presumption of innocence, which is the cornerstone of our legal system. We also are finding, if you ask me, that we're having a harder and harder time with people who come into the legal system as potential jurors who have the ability to apply and to actually apply the presumption of innocence. What does it mean? It's not the way people live their lives day to day. It's not the way people live their lives from moment to moment. You have a person, for example, and I do this when I pick a jury. Think about the way you live your own personal life. You have somebody who comes to you and applies for a job, and they're perfect for the job. At the very end, you say, you know what, you're perfect. I want to give you the job. And the person says to you, I really appreciate that. This job is perfect for me, and I'm perfect for it, and I'm going to be great at it. But in the spirit of full disclosure, I want to tell you that I have a trial coming up next week. So I need to start in 2 weeks, and I'm innocent of the charge that I'm facing. I've been wrongly accused, and I intend to beat this case in court. So I can start in 2 weeks. Is that okay? And when I put that question to jurors, and I do it because I want jurors to have to face the fact that the presumption of innocence, we pay lip service in court. We can't pay lip service to it in court. We have to be honest and open, and we have to embrace it. But outside of court, people would probably in that situation, almost every juror agrees, would not hire that prospective employee. The employee who comes in and says, yeah, this job is perfect for me and I'm perfect for it, but I want to be honest with you, I have a case that is pending against me. I'm going to trial next week, I'm going to beat it. So I can start in 2 weeks. Most of the jurors, when I put that question to them, the look on their face, the same jurors who said a few moments ago that they could apply the presumption of innocence and be fair jurors, when I put that to them and I use that job example, the color almost drains out of their face. Some stammer. Some look at me and say, you know what? It's a good question. It sort of changes the way I'm thinking about things. No. And most say, I probably wouldn't hire that person. And then I changed the dynamic even just a little bit more. And I ask them, well, what if that person, same interview, same job, they're perfect for it, and you're perfect for them? And they say to you, you know, again, it's a great job. In the spirit of full disclosure, I was just accused of a crime, a very serious one. Here is the accusation. I went to trial a week ago and I was found not guilty by a jury. Would you still hire me? And I put it to the jurors, would you still hire them? Even in that case, the same jurors who said that, I can apply the presumption of innocence in this case, I know I can do it, it's important. When I put it in the context and I change it a little bit and talk about their job, their business, and even when the person was acquitted, they hesitate. And they look and they think, good question. I don't know. Probably not, many say. So what that means is that if you are accused and you believe you're innocent, you're not going to get hired. If you're charged and you're presumed to be innocent and actually are acquitted, many of those same employers aren't going to hire you either. What does that mean for the legal system and for jurors? That means that you are innocent or presumed innocent until accused. It means that we're paying lip service to the presumption of innocence when people in their own personal lives wouldn't hire somebody who openly disclosed that they have a case that they're going to beat, or who openly disclosed that they had a case and they won. The level of doubt that people have, that those jurors who are employers have about those in those circumstances, reveals that the presumption of innocence is something that is really difficult to wrap our arms around. It requires a totally different way of thinking. And because in our personal lives, we're so used to just jumping to conclusions, to presuming that there must be some merit to the fact that when a person is accused, that something must have happened, that there must have been something done, there's something wrong. And we need to do better. And I think to myself about every person who was wrongly accused and who was wrongly convicted and ultimately exonerated. Remember, convicted by a well-intentioned, well-meaning set of jurors who all took the same oath that they would faithfully apply the presumption of innocence and that they could do it, and convicted a person based on eyewitness evidence or just a he said, she said, just the account of one person against the other, without forensic evidence, without DNA evidence, who end up being exonerated 2, 5, 10, 15, 20 years later, when science sets them free. I think back to those jurors and I wonder, had those jurors just faithfully applied the presumption of innocence, wouldn't we have avoided all of this mess? Wouldn't all of those, or at least a vast, vast, vast majority of those wrongful convictions that result in exonerations years later, have been avoided? Had the juror who sat there and said, I'm not convinced that eyewitness testimony in the dark at night without great lighting is reliable enough to overcome the presumption of innocence. I'm going to err on the side of continuing to presume the accused innocent and thus acquit him, but instead just accepted whatever eyewitness testimony the government threw at him and whatever arguments were made, or thought the crime was too serious, they can't let the guy go. Think about that. It means that in those cases where eyewitness testimony, and that's all they had from some limited, weak eyewitness testimony that jurors just happened to wrap their arms around, that later proved to be untrue and unreliable based upon DNA evidence, had those jurors faithfully applied the presumption of innocence in that trial 5, 10, 15, 20 years ago, we would have saved a man's life. Same thing in the he said, she said case, where one person makes an allegation, the other person says, I didn't do it. I'm not guilty. And that's all they have is one person saying that they did it and the other person saying with a plea or with testimony, I didn't do it. And the jury decides to side in that case, which is almost impossible to side with, to say that there was proof beyond a reasonable doubt. But yet jurors say, I accept the fact that this person who made the allegation, despite the absence of any evidence, any corroboration, any support, I accept it, and that overcame the presumption of innocence. Imagine had jurors actually sat there and said, I'm not satisfied. One person saying that this person did it, that doesn't overcome the presumption of innocence. I'm still forced to presume that this person is innocent. And thus I have to acquit him, I have to find him not guilty. Again, would have saved a life. It's time for us to start being honest about the fact that if you as a juror, as a citizen, if you in your writings, in your ramblings, in your ruminations online and social media and otherwise, if you're one of those people that tends to believe that people and say, I think he's guilty, or lock him up or lock her up or whatever it is you say when you read something in the paper, I hope it's time for us to say that when you believe that and you come to court, you should be disqualified as a juror. And it's time for prosecutors and judges to accept that. Likewise, it's time for us to get to a better place where when we read something which is alleged about another person, that we have the ability to say, you know what, I don't believe it yet. I'm going to wait. I'm going to resist the temptation to just pile on. I'm going to presume that person innocent. And maybe, just maybe, if we do more of that in social media and in the news and in the world, we'll not just feel better about each other, we'll not get along better, we'll not just have more faith in one another, but we'll actually get more justice in the legal system. We'll actually take what we're applying in our personal lives, in the media and in social media, which is presuming people innocent, presuming them not guilty, believing the best about them, applying that golden rule, and it'll be so much easier for us to do so in the courtroom. And think about how much more justice we're going to get when we do that. This is Neil Rockind. Thank you for tuning in, I should say, to another episode of Killer Cross-Examination, the Presumption of Innocence. It's time to really respect it and apply it and be faithful to it in and out of the courtroom. Because you can't do it in the courtroom unless we start to do it out of the courtroom.
Killer Cross-Examination. A podcast by your host, the nationally renowned criminal defense attorney, Neil Rockind.